lawyers to look into the Middle East and see what they have done, where they succeeded, where they had problems. The main area where arbitration come up is not so much as in the legal in the contract between the main contractor and the Arab client, but what really is prone to arbitration is the subcontracts. You know, you have large infrastructure projects such as airports, ports, tunneling now for underground systems which are put in place, and you have a main contractor, and then this main contractor subcontracts hundreds of services and works to companies all over the world. And very often the main contract is governed by a court clause, dispute resolution clause, which forces you to go to the local court. But in the subcontracts, you're more or less free. And if the main contractor is American, the large American enterprises, for example, and you have a German supplier or you have an Indian supplier, then in this relationship, it's easy to put in an arbitration clause. And this is really what I've done the last years. My main work is in this subcontract relationship, and don't think these are small amounts. These are huge amounts. Entire machineries are being shipped to those countries, and we see arbitration popping up everywhere. The advantages, of course, is language. You don't have to go to the Arabic spoken court system, and you have international experts. And I would just close my remarks. The most important decision is not really the procedural rules, but the rule, the arbitrator you pick at the end. You know, it should be a person who is multilingual, a person who is well known with the area you work in. And the beauty of arbitration is that you then, together with the arbitrator and the parties, design your own, what they call terms of references, i.e. the own procedural routes, custom-made and bespoke to that very arbitration. Thank you very much.
Thank you, Oliver. That was very instructive. And before we turn now to hear from the four representatives of as many countries how institutional arbitration works in their countries, I should perhaps point out that you can, of course, also always have your what we call ad hoc arbitration. So where you do not use any institution, but select your arbitrators, and since it is the parties that are in control of the process, which is one big difference from the regular court systems, is the parties that are in control of the process. They can practically decide anything, how they want to have the procedure go. So I'm going to invite first Caroline Bechter from Germany, then Shehara Varia from Sri Lanka, then Sheherazada Dubash from Singapore, I'm sorry, write the odd man out, Aditya Kurian from Hong Kong to give us their input. Caroline?
Okay, so thank you very much. Thank you very much for this kind introduction. And let me tell you that it is a great pleasure and an honor for me to be at this very prestigious panel and to contribute to this interesting and lively discussion, hopefully. Maybe, first of all, I would just give you an overview of the German Institution of Arbitration and follow this approach just to give you a general idea of what we do and who we are. And not in order to compare the both systems, because the legal cultures are certainly quite different, but to give you an idea and maybe some incentives of how it can work in a different way. So the German arbitration, the German Institution of Arbitration is one of the leading German institutions of arbitration and one of the international arbitration institutions. It is well established both for international and domestic arbitration in spite of its name, German Institution of Arbitration. The international part is steadily growing. We're approximately at 30% of international disputes at the moment. The German Institution of Arbitration is a fully independent institution. This is important to point out because unlike most other institutions, the DIS, as is the abbreviation of the German Institution of Arbitration, the DIS is completely independent from any chamber of commerce, for example, or any other state entity. In this way, it sets its own policy, which gives the DIS, on the one hand, a high credibility, and on the other hand, the flexibility to quickly respond to its users or the market's needs. The German Institution of Arbitration is located in Germany. It has its legal seat in Berlin, thus being in the political center of Germany, which is, I think, an important aspect. The main secretariat where the day-to-day case management is done is situated in Cologne, which means that it finds itself in the strategic and infrastructural center of Germany. Being located in Germany holds the advantage of benefiting from an arbitration-friendly legal environment, which may not always be the case in India, as I've heard so far. So, Germany revised its arbitration law in 1998, thereby basically implementing the provisions of the worldwide recognized UNCITRAL model law on international commercial arbitration. And as well known, the balance between judicial intervention and judicial restraint, the balance between judicial control and judicial support is of essential importance to the existence and the development of arbitration. So when revising the arbitration law in 1998, the German legislator was very much aware of this paradox and decided to endorse the principle of judicial non-intervention in the arbitral proceedings as a salient feature of the German arbitration law. And still, arbitration itself, and especially the success of arbitral proceedings, of course, very much depends on the state court's assistance during and after the arbitral proceedings. And that is why the power of state courts to intervene in arbitral proceedings is very specifically regulated. It is expressly regulated and is exhaustively regulated in the German arbitration law. In this regard, I might cite the section 1026 of the German Code of Civil Procedure, which regulates the extent of the court intervention and provides the following. In matters governed by sections 1025 to 1061, which is the arbitration law, no court shall intervene except where so provided in this book, so in these provisions. So you have very specific regulations when a court is allowed to intervene or is allowed to provide assistance to the parties or the arbitral tribunal. It is also important to note that the courts are neither entitled to supervise the arbitral proceedings nor the outcome of the arbitral proceedings, which contributes to legal certainty, of course. The very limited state court's intervention in arbitration is generally focused on lending support to the arbitrators and the parties, as we have already seen is the same in Switzerland. And they do so, for instance, by appointing arbitrators in the event that the party fails to do so, or assisting in taking of evidence as well. Of course, in the procedure of challenge of arbitrators, the court may be involved or when setting aside the arbitral award. And all these provisions of the German arbitration law apply both to domestic and international arbitral proceedings. So I think I have a lot of more to say, but maybe I just stop here and we just go into the discussion later on.
Yes, Caroline, that's a good idea, and that, in fact, I hope we will be able to do, time permitting. And before I invite Shihara Varia, the General Secretary of Sri Lanka Arbitration Center, I'd like to pick up on one point, namely the issue of court intervention. In modern arbitration systems, that is something one wants to avoid. So in those systems, usually, it's only at after an award has been rendered, when you want to challenge the award, you, of course, can and I think must be able to take this matter to a court, but only under you will be successful only under very limited circumstances. And of course, at the enforcement level as well. usually under the New York United Nations Convention to which most countries in the world have subscribed. And I think it was again Switzerland at the forefront where the courts said that even when you are challenging an award at the enforcement level, that doesn't necessarily mean that the enforcement needs to be stayed until you know what the outcome of the challenge was. So I think that again shows you how much one can limit it to the necessary minimum, I would say, keep out the courts in the arbitration procedure itself. Shihara, you wish to make your comments? Thank you.
Thank you, Axel. It's always a pleasure to be in India. It's like a home away from home for me. I just thought from a regional perspective, I'll give some thoughts. With regard to India and Sri Lanka, as you all know, we have an interwoven long history and culture due to the close ties we've had for thousands of years in relation to trade. And arbitration is not a new subject for us. It started by way of village councils, which we call Gam Sabha in the Sinhalese language, and I think there is a similar term in India as well. And it was only after British rule that the court system got deep-rooted in the arbitration proceedings with legislation introduced by the British. In 1995, Sri Lanka adopted a new arbitration law in line with the ancestral model law, which promised a more user-friendly system of arbitration, so to speak. However, I think the broad concepts of party autonomy and minimal judicial intervention were a little difficult to digest in an adversarial environment. Reading the recent Law Commission report that was by the Law Commission of India, it appears that our problems are almost exactly the same. From a procedural point of view, the per-sitting fees for arbitrators, retired judges controlling the proceedings and duplicating court procedure, arbitration being considered secondary by lawyers. In fact, in Sri Lanka, the most successful arbitrations are in the construction industry, where it's led by engineers and consultants rather than lawyers, and delays in the conclusion of proceedings and thereafter in enforcement. And of course, the difficulty in obtaining interim relief, particularly because of Section 5, which I think is common in both our laws, particularly prior to an arbitral tribunal being set up. I think while amendments to relevant provisions in laws will certainly help to bring clarity, in my view, there's a larger picture. And I think there's a dire need for education and training in the process of arbitration for all those involved, including judges, lawyers, and other parties. 10 years ago, Sweden, because Sweden also helped us draft arbitration law, and arbitration, the only institutionalized center in Sri Lanka, which is the ICLP Arbitration Center, is modeled on the rules of the Stockholm Chamber of Commerce, the Arbitration Center of the Stockholm Chamber of Commerce. We feel that this training had some impact on the way arbitration is practiced now in Sri Lanka. It's not the ideal situation, but it's getting somewhere. Courts are beginning to realize that they should play a supportive role and are recognizing arbitration agreements. In a recent judgment by the Supreme Court, the parties had a badly drafted arbitration clause, but because the parties had in fact agreed to arbitrate, the judgment was that they should arbitrate in terms of the Arbitration Act, because the intention of the parties was very clear. And I believe that regional training, approach to training will be more effective than us trying to do it on our own. And we have a lot to learn from regional centers as well, like Singapore and Hong Kong, which have a fair amount of arbitration experience than maybe India and Sri Lanka. I think the synergies are unlimited. It could be more effective for parties in South India, for example, to arbitrate in Sri Lanka, and vice versa, rather than even in other parts of India. And therefore, we do not need to look very far for neutral venues. However, we need to have the confidence in each other's system, and this will only happen if we have familiarity with each other's system, which are not too different. I mean, since most countries in the world today are following the ancestral model law. Therefore, I'd like to leave a thought amongst the regional centers here and also the European centers who could help us in, I think we need to set up some sort of programs where we train arbitrators, judges, young lawyers, and other commercial parties because if we do so, I think we'll have a lot of neutral venues in the region itself to choose from, and which will be certainly more cost effective to commercial parties. Thank you.
Thank you, Shiara. And in fact, you're not alone in your own country. There's another institution. I'm asking that question because I think for a country the size of India, you probably will be needing several of these institutions in the various important commercial areas, Delhi, Mumbai, etc. You know that better than I do. So may I now turn to Sherazada Dubash. She is Deputy Head South Asia, Singapore International Arbitration Center.
Thank you, Axel. Good afternoon, everyone. It's a pleasure to be here, and thank you for having me. I hope you will indulge me for a few moments whilst I talk about the Singapore International Arbitration Center, or SIAC as we'd like to call it. SIAC, as most of you may know, is a relatively young institution. It was established in 1991. Over the past couple of years, we've seen a lot of interest from Indian parties. In fact, last year, our largest contributor of cases came from India, which is 85 of 257. So a third of our total caseload came from Indian parties itself. And barring last year, over the past 4 years, we've been seeing India as in our top 1 or 2 top contingency of cases. Last year, we decided to open up a representative office in India. Our representative office is in Bombay, which is where I am based and primarily operate out of. The purpose of that office is to spread awareness of arbitration under the SIAC rules. So what I do and what SIAC does in India is that we actually go out to companies, to law firms, we give them an insightful knowledge of how arbitration works. If they would like to focus on any particular provision, we explain how that works.